Very good evening, my dear friends. In today's session, we will discuss about the banking ombudsman. Because after the study of the rights of the customer, rights of the banker, and so on and so forth, we will have to understand in furtherance of the rights of the customers. It is the banking ombudsman which has been provided to cater to the needs of the customers who are aggrieved. And in that concept, this subject is very important. Actually, the main aim of providing banking ombudsman is to, in fact, create a forum by the government which would work expeditiously as possible, and then which is also inexpensive for the customers to resolve their complaints, their disputes relating to the various banking services. This particular scheme was first introduced by the Reserve Bank of India under Section 35A of the Banking Regulation Act 1949 in the year 1995. Subsequently, it has undergone revision in 2002, and further again it is revised in 2006. It is subject to revision from time to time, of course. In the year 2009, the scope has been widened very much. And then today, several subjects are covered. And then subjects like credit card compliance, deficiencies in providing promised services, deficiencies arising out of internal banking, whatnot. Several issues pertaining to the banking services are covered under the scheme. The entire scheme is funded by the Reserve Bank of India, and the Reserve Bank of India provides the office and then other necessary mechanism for the ombudsman. And complaints can be filed online as well as offline. And then, in fact, the awards given by the ombudsman are challengeable as an appeal to the Reserve Bank of India itself. Now, what are the details of this particular scheme? Details means what are the various issues pertaining to this. Firstly, the banking ombudsman happens to be a senior official appointed by the Reserve Bank of India in this regard. Several banking ombudsmen are appointed in different places in the state capitals today. Then, under this present banking ombudsman scheme, all scheduled commercial banks, regional rural banks, and scheduled primary cooperative banks are also covered, and they come under the umbrella of this particular ombudsman scheme. And this particular ombudsman deals with deficiency in banking service. And any customer, before approaching the ombudsman, of course, must first approach the bank first and convey its grievance. And if the grievance is not redressed, and then he should approach the ombudsman. This is the primary principle before approaching the ombudsman. The ombudsman, on receipt of the complaint from the customer, obviously will issue notice audi alteram partem to bank and try to settle the issue amicably, and failing which, then he will pass an award. After giving an equal opportunity of being heard, he can reject the complaint if it is frivolous or the compensation sought is beyond rupees 10 lakhs or requires consideration of very elaborate evidence. Then he will say go to court of law. He can also reject if he finds that the complaint is without any sufficient cause or that it is not pursued by the complainant with reasonable diligence. It's not pursued by the complainant with reasonable diligence. The awards passed by the ombudsman, friends, are appealed to the appellate authority within 30 days of the receipt of the award, and the appellate authority may condone the delay for any proper reason being shown for another 30 days. Then the appellate authority may dismiss the appeal or allow it by setting aside the award or send the matter to the ombudsman for fresh disposal In accordance with such directions, as the appellate authority may consider it necessary and appropriate. And it may even modify the order, award, and pass such directions as may be necessary to give effect to the modified award, or pass such any other award as it may deem fit and proper in the circumstances of the case. Further, against the order of the appellate authority, the aggrieved has no further appellate provision in the statute, but he can approach the High Court under Article 226 or the Supreme Court under 32, and then further he may move the consumer forum also. He can even go to civil court in a different way, but I feel it is not correct either Article 226 or 32 of Constitution of India or going to consumer forum must be the right remedy in fact. And friends, you please go through the Ombudsman scheme thoroughly, which is available in the RBI website. That will throw more light on this particular subject matter. What I find is that this Ombudsman system is working, of course, in some places well, some places no. Some cases the orders are specifically stated to be not appealable. Then there is no other way except that the matter should be taken to High Court or the Consumer Forum. There is no bar. Consumer Forum is additional remedy. So that is how this Ombudsman is functioning. So with this background, friends, we have in fact discussed several issues pertaining to the relationship between the banker and the customer and different modes and types. And then we'll continue further our discussion now with regard to the establishment of RBI and the powers of RBI. And so soon we'll be completing the discussion on the banking subject matter. So, friends, we'll be in touch again. I will come back to you with further lessons on the subject of banking and negotiable instruments. Thank you very much and good night. Bye bye.